I'd like to introduce Adam Leitman Bailey, who is a real estate attorney and founding partner of Adam Leitman Bailey PC. He's going to present a great lecture today on residential cases, laws, and orders you must know and understand, from the Spanish Influenza to COVID-19 to effectively practice law. Adam, thank you so much for being with us today. I'm going to leave it up to you now.
Thank you very much, Diana. Thank you, Judicial Title. It's been great working with you for almost 20 years. And you are, besides one of the best title companies, you were one of the greatest CLE providers that I've ever performed against in the last 20 years. It's amazing how old I'm getting and how many times we've spoken. Okay, let's get to business. I'm losing my voice because the amount of hours that we're giving advice during this pandemic. And let's go into why. So let's get right into it. The COVID pandemic has confronted building owners, managers, and the boards of New York City rental condominium and cooperative owned buildings with operational challenges that few, if any, buildings have ever experienced since the so-called Spanish Influenza pandemic 100 years ago. By the way, please ask questions during this lecture. Don't wait till the end. I don't think we're going to have time at the end for questions. We may or may not have it, but give me the tough questions. Give me everything. Because every one of these slides is going to have things that are thought-provoking, I hope, and that's the way I made it. Like, for example, this slide, the primary responsibility of building managers, whether they be owners of rental buildings or members of cooperatives or members of the board of managers or condominiums and their respective property managers or managing agents, is to maintain the health and safety of their buildings and their occupants. Multiple dwelling law too. Well, let's look at this. Ownership is required to maintain the building common areas, right? Ownership's duty is to maintain the building in a manner that protects owners, occupants against the spread of disease. You even have a law that says that the building must maintain the health or safety, it says right here, or pay a penalty. What is the maximum penalty? Under the health code of New York right now, it's $2,000. Well, what happens when, let's say you're an owner in a condominium and you team together with the other 200 residents in your building and your gym's still closed? Today you show the executive order that allows several people to use the gym. It's no longer illegal to use a gym. You can have limits on how many people can use it, but you're allowed to use the gym. So you say, okay, I want to use my gym. And condo says, no, we still feel it's not safe. Well, who's going to win that war? And what if it's a co-op? You have the business judgment rule versus the people in the building, the owners of the building that says, well, I have this deed here. And it says that I own some of the common elements. And then you have the business judgment rule where they get to make decisions based on the building. These are questions that haven't been answered yet. These are really tough questions that have never been answered in the history of our time. I mean, there's many cases that have said, well, we're going to give a wide deference to the board of directors of co-ops and condos. But at the same time, how long, at the same time, how long can we, one second, I got to get rid of this call. At the same time, how long can we deny them the ability to use this premises? And one of the things that they're going to have a problem with is proving damages. Not only are they going to have to, well, you have the one thing of their owners, and then the board is going to say we have the duty to protect you. Then the next thing is, okay, they sue ownership versus the business judgment rule. The next part is I've been harmed. Well, okay, what's your harm? So in the case, the first part of it is you haven't been harmed. You're going to see the cases coming up from the Spanish Influenza the smallpox epidemic, the scarlet fever. What's your harm? How have you been harmed? And then getting into that, if you have no harm, okay, you don't have that. Then the next part of it is the owner versus the board. And those answers I don't have the answer to. I'm just setting up the issues that both the attorneys for the board and the board versus the owners, these are cases that will be coming and are already starting to come in. Okay, here's a...
Adam, I actually have a question if I could hop in.
Sure, please do.
Somebody's asking, are users of space as office space users allowed to void their guarantees to escape their liabilities as guarantors under the present City Council resolution, allowing retail shop, restaurants, and nail salons to void their guarantee?
All right, so we're going to get into the guarantee law in this lecture in about 20 minutes.
Thank you.
In detail. So let's hold on to that question for now because we're going to have 4 slides on that. If we could just hold on to that. But it's a great question, and I'm glad I'm answering it later on. But thank you. Why is it so important to go back into rulings that are 100 years old, or in this case, 120 years old? And there are some judges on this. There are some judges that are watching right now, judges and former judges. Thank you for tuning in. So when judges are always trying to do the right thing. And I think we have excellent judges in New York, especially that they're listening. No, I'm kidding. But so they're trying to do the right thing. And they look at things called precedents. And what precedents do they have besides the more recent laws? But when they're looking at cases for the first time, they don't have to look. There has been pandemics before. They don't have to look that far. They have appellate cases, Court of Appeals cases, going back that cover these exact same issues. And the law is very clear. And here's one of those cases. Majestic Hotel versus Ear, 1900, First Department, Appellate Division. Let me move this over because it's blocking my ability here. Thank you. Okay. This is a case of the scarlet fever. The court declared that the landlord was not guilty. It did everything it had to do to clean out the premises. It took all the precautions to prevent the epidemic. It went in, it did all the cleanings, it followed all the rules to prevent this contagious disease. And as a result, the court declared that the landlord was not guilty of negligence. Therefore, the tenant, let's read from it. A case might be made which would avail as justification for the surrender of the premises, but not in this case. If the landlord was guilty of an affirmative negligence or negligently suffered acts to be done by which a contagious disease was introduced into a thickly populated hotel or tenement house, or upon the breaking of a contagious disease upon the premises, if he, retaining and exercising a general control over the public parts of the house, should negligently omit to take precautions to prevent the spread of the epidemic or otherwise protect the tenants from contagion when the means lay within his power to do so, a case might be made that there should be a surrender. The tenant is trying to get out of the lease. The court said, no, this landlord did nothing wrong. Therefore, there's no constructive eviction. Now, let's compare it to a case in 1895 below. Sully versus Smith. This is in Buffalo. The landlord did not protect the sewer, did not tie up the sewer. Secretions, number 2, as we would call it as kids, was coming out into the secretions was coming out into the dropping down into the apartments, and the court held that there was a constructive eviction because the landlord was responsible for taking care of the sewer system, and it did not, and therefore the tenant could get out of their lease. So back in 1895 and 1900, there was the same laws we had now as far as constructive eviction. And if it was the landlord's fault, they got out of the lease. If it's not the landlord's fault, they didn't. But back during the pandemic, back when we really felt for these tenants, back when we really had a big heart, back when things were really bad, as of now, they followed the law. That is the key to all these cases, and I've read dozens of them. They followed the law. And why am I having trouble turning pages? Hold on a second. Here we go. Okay, among the lessons taught so long ago by the court in Majestic Hotel versus Ear include the following comment addressed to the tenant who abandoned his New York City apartment to ride out the scarlet fever. And this is very apropos to today. So far as the physical surroundings were concerned, the apartments were habitable when the defendant voluntarily vacated them as when they were leased. It is also clear that after the fever was discovered, the usual precautions known to science were taken to isolate the cases and prevent the spread of the disease. There are about 400 persons occupying the apartments. I believe on 72nd, there was 2 Majestic hotels I researched, one on 72nd, one on 51st. I think it's the one that is now still standing on 72nd. It's no longer a hotel. It's now I think it's a condo. I'm not sure about that, but it's no longer a rental building. There are about 400 persons occupying apartments under lease in the hotel at the time of the breaking out of the fever. And for the most part, if not all of these tenants, they continue to remain and occupy their apartments without detriment to either health or comfort. The defendant abandoned his apartments on account of the fear of contagion to himself and his family. We are therefore to see if it's sufficient to excuse the payment of rent. We know of no ground upon which the payment of rent can be successfully resisted. The court continued. To constitute eviction, there must be possession by paramount title, acts on part of the landlord, of those persons subject to his control, which make the occupancy so uncomfortable that the tenant is justified in removing therefrom. In this case, it didn't exist. Here is a picture of the hotel on West 72nd Street in Central Park as it stood at the year of this case. Another case, and I'm blocking it here. This is 1901. Same thing. The landlord sued to dispossess the tenant who had failed to pay the rent for August and September. Very confusing case. I had to read it 5 times. On the 2nd of July, the tenant had been afflicted with smallpox. Smallpox today is no big deal. Back then it was a big deal. Now we get a shot for it when I think we're 4 or 5 or 6 years old. Was removed by the health. So the tenant was removed by the health authorities to North Brothers Island, where it remained for 7 or 8 days. North Brothers Island, I had to research, was used during the pandemics of the time, has never been used since. This is where some of the most famous, like Typhoid Mary went there. The most famous people of the pandemics resided right off of the Bronx. And it's now a vacated island. And I looked it up, and I don't know why we're not using it for things. But this person remained there for 7 or 8 days. Upon tenant's removal, the health department required the building to do a bunch of things. They did it. But the tenant never surrendered the keys during this time. He paid into court September's rent, for which he was found liable. The lease was still in effect. And the municipal court had said he didn't have to pay for the time that he was taken away to this North Brothers Island. It goes to the appellate division. And the appellate division disagreed. They stated, we were at a loss to discover how these facts establish an eviction of the tenant or any defense, whatever, to the proceeding. Bottom line, there's no constructive eviction unless the landlord caused it. The court continued. The tenant was not prevented from occupying the demised premises by any act of the landlord. This is my 5-year-old son, Benjamin. So, on the contrary, any deprivation of the use was a result of the tenant's misfortune in contracting a malignant disease which required the health authorities for the public good to quarantine the tenant for a reasonable time.
I want TV.
Yes, to prevent the spread of the evil. No attempt was made to prove the prevalence of a contagious disease in the house, nor does it appear that the tenant contracted the disease in the house, or that anything growing out of the relation between the parties had anything whatever to do with it. The court is saying that the landlord is not responsible if the landlord did not cause conditions that would cause a disease. Number one. Number two, if the landlord didn't cause the disease or have conditions to cause the disease, the landlord has a right to collect its rent. Even if acts arose to the dignity of a constructive eviction, they would constitute no defense, not having been followed by an abandonment of the premises and a surrender to the landlord. It was sent back for trial to the trial level. Now, what does this mean? From the last crisis, very few law firms, very few people, because of the ELSA statute, if you know anything about our firm and those cases, have done as many time in the essence notices and as many breach of contract cases as our firm. So there's been no law on this yet, but I'm going to give you my 2 cents on the cases where we have tons of them in our office, where people are trying to breach their contracts of buying homes. Now, looking at the law and looking at what's going on and look what's happening. If you're on the seller side, the buyer indicates that they're not closing and they want their deposit back. And they're telling you, we're in a pandemic. Their client has horrible conditions. The worst has happened to their clients, the client's family. They are at a certain age. I mean, the excuses are very heart-provoking, and I really feel for a lot of these buyers. But when it comes down to it, a contract is a contract is a contract is a contract. However, if you're the seller, imagine taking your property or taking your apartment and selling it in this new market, which I call the pandemic market or the post-pandemic market, which I also call a guaranteed depression that's going to be coming. I mean, why? I mean, imagine shutting down businesses for this long. Imagine having our federal and state governments that have no idea how to run businesses. Imagine the deficits that we have without having a government that understands how to run businesses. I don't think there's any way around having a severe economic consequences. As a result, I would not want to be selling an apartment in a new market. So I use the word Rahmanis. The first thing is take into account any COVID-19 related circumstances that may result in your agreeing to delay the closing. You want to look good to the judge that you have to assume you're going to see one day. So number one and number two, if you can make a deal and discount the price of the property, advise your client to do so. Because I'd rather be closing this deal and give them a discount than be reselling this property in the worst market that you've seen since the American Revolution. Number two, if you don't give the buyer time to close and you force them in a short time frame, you're helping the judge rule against you. So as long as your contract is buttonholed and there's no way to get out with the mortgage contingency by giving them too much time to close and everything's in order and the closing attorneys did a good job, please give them a long time with your time of the essence notice. So you send out your time of the essence notice, then you agree to adjourn it. We got to make sure you do a really good job with those time of the essence notices. Make sure you have a litigator looking over those notices. At the same time, you may want to accelerate the date. If the financing is going to disappear because the people may lose their job, you may want to reverse what I just said and not give them the time. You definitely need to give at least 30 days, but you don't want to give the 6 months like sometimes we're doing. If you have a feeling that their job may disappear, because if the job may disappear, then the financing goes away, then you're not going to be able to sell it to them anyway. So it's a case-by-case basis. So you want to have charity, you want to give out charity and you want to be charitable with the time and the ability to give them time. At the same time, if you give them too much time and they lose the ability to get a loan, and by the way, credit's tied up. The banks won't give you a loan with less than 700 credit score. They're the major banks. They're some of the major banks, most of the major banks. They're requiring 20% down. They're no longer are they giving HELOC or home equity loans. So this is a different credit system than before the pandemic. Understand the new market the seller may be entering into. So we got to be really reasonable. But otherwise, the courts during the Spanish flu and the scarlet fever and the smallpox and all the other pandemics enforced the law. Evictions.
Adam, I have a question. Going back to the smallpox case, who had the obligation to fumigate, the LL or the tenant? If the LL and work is not completed in August, is the decision questionable?
Wait, is this during the Spanish flu, scarlet fever, or now? The question.
They did not specify. They just said in the smallpox case. Okay,
in the smallpox case, and the scarlet fever and the Spanish flu, the government would order the landlord to fumigate and to get rid of the government would come in and order you to an order at the landlord's dime to get rid of these, pandemic causing problems. Now, I'm not seeing in our hundreds of or thousands of buildings, I'm not seeing the health department come into too many buildings. It appears during the pandemics from 100 years ago or more than 100 years ago, that the government was more hands-on and they really had it more together than our local governments today and our state governments today. So today it's more our co-ops and condos, the boards have it more together than the government coming in and telling you what to do. So in these cases, the government would come in, judge you, tell you what to do, watch it. So these judges had a report to look at when they were making their decisions. I hope that answers the question. Okay, moving on to evictions. This is brand new stuff, very fluid. And these slides had to be changed a few days ago. Some of them even 24 hours ago. Okay. Housing court opened last Monday. It also closed last Tuesday. So you can start an eviction case in housing court, but then it's adjourned for months. No evictions will happen until late in the summer, we're told, by a memo from the chief administrative judge. This is complicated. So let me go slow. No evictions for non-payment of rent can happen, according to the governor, until August 20th. If you are eligible for unemployment benefits or otherwise facing financial hardship due to COVID-19 pandemic. That's Executive Order 202.28. That's the governor's order. However, so as of August 20th, you're good to go. Everybody can be evicted, right? The governor's order is the highest order you can give. Wrong. Somehow, some way, only in New York. We received a memo from the chief administrative judge, Justice Marks, and he said, no, I am going to go farther than the executive order of the governor. I'm going to disregard that. And housing court, you could start new cases, but housing court will only be open for conferences for cases that were started for pre-March 16th, pre-pandemic cases. Housing court will not be processing post-March 16th cases in New York City until later in the summer. This memo came out last week. So if you start a case in housing court, it'll be started and you'll be on hold. You'll be getting a date, a court date. It'll be adjourned for many months. I went on a record for a newspaper and I said, I don't understand how an administrative judge can overrule the governor of New York. Then again, I am just a small-time attorney and I don't have the power to do anything but sue and declare my constitutional rights, which would take a while because everything slowly. So what is a lawyer supposed to do? Our firm, and I recommend your firms, bring your housing cases in state Supreme Court. There is concurrent jurisdiction. In the law, which some people are following, you could bring a housing court case in state Supreme Court. It's concurrent jurisdiction. Now, remember the facts of life right now. 80+% of our clients' tenants. And we have one of the larger, as 20+ attorneys, we have one of the larger real estate shops in town. So 80+% of the residential tenants have been paying rent. Only 40+% of the commercial tenants are. So we're focusing on the commercial tenants. The memo by Justice Marks overruling the governor applies to commercial and residential. I need to give you your code for your CLE and your CE. The code is Adam Leitman Bailey. Adam Leitman Bailey is the code you need to fill in. Adam Leitman Bailey. And if you don't know how to spell it, it's behind me on the screen or on these slides up on the top. Adam Leitman Bailey is the code. Okay. So we're bringing the cases in state Supreme Court. They have to take him because it's concurrent jurisdiction. At any day, they could turn around and say, okay, stop. If that happens, we're going to assert what's going to be in this lecture, and we're going to talk about this lecture of why and how they're unconstitutional. Let's go to it. I know there's questions, but I can't see them on my screen. Hold on, let me just see if they were emailed to me. Okay, and okay, they're not. Okay, that's housing court. Mortgage foreclosures. Same thing. The executive order for mortgage foreclosures extends until August 19th or August 20th, stopping residential foreclosure lenders of mortgage foreclosure proceedings for non-payment of any borrower eligible for unemployment insurance or benefits under state or federal law or otherwise facing hardship due to COVID-19. The order does not prohibit foreclosures for reasons other than non-payment. That's the executive order from Governor Cuomo. So we're excited because it takes me about 4 weeks to get into court. Then it takes months to get going, to get to that chopping, that eviction, that final writ of eviction, where I could sell the home, the auction block. So we're okay with the August, even in April, we're okay with August. And then Judge Marks puts out his memo. This happened a few days ago. This is Thursday or Friday. Foreclosure matters, this is his memo, can proceed when both parties representing by counsel are there for settlement conferences. Lenders may move for judgment or foreclosure when a property is vacant or abandoned. No motions may be made or decided. In other words, you can't make a motion in court. Imagine that. By the way, the reason I'm telling you this is that very few people got this memo. I mean, unless I don't know, there's no database that every attorney gets this. So I understand how important this information is. You can't make a motion that can be decided. So in other words, everything's shut down. At or before August 20th, there'll be further directives or be ordered. 2 new forms must be filled out with new cases when they are allowed to proceed. The first form says that if you have COVID-19 related problems or you are unemployed, you get extra time. The second one is bilingual. The memo from Justice Marks came out late that night on June 23rd, 2020 to the judges running the courts. And then it's quickly spread to a bunch of a group of attorneys. Okay, let's get into some of the executive laws that are in existence, and then we're going to get into the constitutionality. And I realize that we're running out of time. Late fees. No late fees can be charged from March 20th to August 20th. I don't know if this is permanent or it's temporary. However, under the United States Supreme Court decision and the history of our nation, it would be unconstitutional for this to be permanent. To ban late fees permanently. If you look at the law, the executive order on the top, it says temporary. It says temporary. So I'm going with temporary for these late fees. I would apply them after August 20th. You could quote me. Not that does any good. Security deposits. This is interesting. because this is temporary. The executive order says that you can use your security deposit to pay your rent, but you have to pay this back over 12 months. And the tenant has to inform you in writing. Just read this. By the way, these slides are going to be available to you. If I believe Judicial Title is going to have them available, otherwise email me if that's not happening. But Judicial Title is very good at what they do. So now, the only tenants eligible now under the new rules as of today are people eligible for unemployment insurance or benefits under the state or federal law or otherwise facing financial hardship due to COVID-19. People do not know that. People do not realize that these benefits, that this security deposit as of July are only available to people with these options. As of May and June, it was for everyone. That has now changed. Repayment of security. Payments must commence repayment within 90 days. You have a year to pay it back. Monthly installments of 1/12 of the amount so applied. Okay, the New York City Guarantee Law. I knew this is one that's a hot one. This is a ridiculous law that is unconstitutional, guaranteed. Why? Let's go into it. And everyone's getting this wrong. This is very important. The law comes into effect. It applies to any guarantees from March 7th, 2020 through September 30th, 2020. So it's March to October, March to September 30th. So after October 1st, the guarantor is on the hook. Before March 7th, the guarantor is on the hook. This does not bar landlords from suing guarantors for rent or other financial obligations that arose either before or after COVID-19. The economic defaults from which guarantors are relieved of enforcement include, this is important, utility expenses or taxes owed by the tenant under the agreement or fees and charges related to routine building maintenance owed by the tenant under the lease or rental agreement. This is why it's unconstitutional. There's a United States Supreme Court case that says that you could have time to pay your mortgage payments late. That was held constitutional 4-3 in 1933. That probably would not be upheld today, but still is good law right now, but it wasn't permanent. This law is permanent. I don't think this is gonna hold up. And the reason is this enforcement on the guarantee is permanent. Now, why are people getting this law wrong? This slide. The law is very limited because they were trying to keep it constitutional, and the city council, of course, didn't consult real estate lawyers when they were drafting it. It's only limited, though, to restaurant and bars banned by the governor's orders from on-premises food, retail establishments shut down for being non-essential, gambling facilities, gym, fitness centers, and classes and movie theaters, and number 5, hairdressers and other cosmetic establishments. Everyone else, all the guarantors, are still on the hook. So if you're not under these 5, your guarantor is still in effect. We can hold you to it, and that's it. Everyone's getting this wrong, especially the tenants with guarantees that think they're off the hook. But you need to know this because a lot of people think that they can't go after their guarantors, and they can. If you're not in these 5, you can go after your guarantors. The only guarantors this law protects are actual human beings, regardless of whether they're good guy guarantors or full guarantors. The guarantor is another business entity, such as a corporation, limited partnership, or LLC. This law gives it no relief. If it's a separate document, good question. I'm not so sure which way it's going to go. I don't think it protects it. By the way, most importantly, the guarantee law does not apply to residential occupancies. Now, here are ways to find this unconstitutional. Number one, you can't close down the courts. This has never been used in my lifetime, or most people's lifetime. Article 4 of the United States Constitution, the Republican form of government, guarantees to every state in this union a Republican form of government. Although rarely used in its history, the closing of our courts appear to violate the sanctity of this clause in the Constitution. At the time of this writing, new housing court cases cannot be started, yada, yada, yada. So by closing down courts is one of the basic things that is part of our country. You have our legislature, you have the courts, the freedom of the press. By taking any one of those away, we don't have a government. And this is one of the arguments that should be raised. The Republican form of government. You may never have heard it before. Please use it when you argue in court of why the courts need to be open in your defenses. Okay, the contract clause versus a home building loan in Blaisdell. The executive orders and Justice Mark's memos and everything else that's going wrong. And the contract clause says that the government cannot interfere with private contracts. That's a contract clause in black letter ruling. Then there is the United States Supreme Court case I've referred to several times. It's called Home Building and Loan versus Blaisdell in Minnesota. State of Minnesota says that the lenders, you do not have to pay your loans on time for a few months temporarily. Blaisdell, 4-3, 1933, they win. It's good law today. However, this was temporary. A lot of these laws are not. But now you have a Republican United States Supreme Court. I don't believe it's going to hold up. And there's very few decisions that have been lambasted as much as this case. But beware of Home Building and Loan versus Blaisdell, because it's going to come to haunt us. I don't know if the city council was aware of it, but this is the case that my office is very well aware of, and we're working around it on our cases. Here is the contract clause, the law. I made these slides user-friendly so you can use them in your cases, because we're already using them. I was very worried when they opened up the state Supreme Court that there was going to be an article about how many cases we filed. There wasn't, thankfully. This is a description of the case I just mentioned. This is the privacy laws. What you're going to be shocked most about, and one of the things is when someone has COVID-19, you have to be very careful. The buildings were very careful not to mention the person's name. However, they tell you which floor, which unit number, and they tell the people on the floor, the person, in that hallway, we can't give you their name, has COVID. I don't know what the difference is between, you gave out their apartment number, what's going on, everything else, but you didn't give them their name. So we had a lot of calls representing hundreds of co-ops and condos of, what are the laws of privacy? We're not going to have, we don't have much time to get through these, but let me go through a couple of these. Information about one's body and state of health is a matter which, we got to check for questions. And we're doing good.
Adam, you want me to read some questions out to you? Or you want
yes, please. How much time do I have, by the way?
You have about 5 minutes, but, we can stay on for
okay, no. Okay, so let's do some questions now.
Sure. Does the no late fees apply to commercial tenants only, to commercial tenants or only residential tenants?
It's very ambiguous. I don't have the answer.
Okay.
The way the executive order reads, you would think it was only residential, but on the top, you believe it's only residential, but then you read other things and it looks like it's both. I do not know the answer, and I'm not going to go under because I'm litigating this. I am going to plead the fifth on that.
Okay. Can Supreme
If
Court
you,
notices,
well, hold on. If you email me privately, I'll give you what I really think.
okay, got that, guys? Can Supreme Court notices, summons, complaints, evictions be started at this time, even if evictions are stayed until 8/20?
Yes. Remember, if you read the executive order carefully, the only thing you can't do is evict. You're allowed to. It doesn't say you can't. Unlike some of the memos being handed out, the executive order only stops you from evicting. It doesn't start you from processing cases. So yes, you can start cases in the state Supreme Court.
Okay. Are there any bills being considered to help small landlords who are not receiving any rents?
Yes, but for me, there's a whole bunch of laws and bills and everything going on, and it's just good lobbying. But until a law is being considered seriously, I don't give it the time of day.
Okay. It was my understanding that if you have a judgment and warrant, we will need to move for leave to execute upon warrant. Is that correct?
One more time.
Okay. It was my understanding if you have a judgment and warrant, we will need to move for leave to execute upon warrant.
If you have a judgment and warrant, you'll need to leave to execute upon warrant. By the way, if you have a judgment and warrant pre-COVID, you're going to need to make a motion to get that going because they're not actually, you're going to ask your marshal to go for it, try to do it and see how far he or she gets. But you may because it's so rare and so new, you're probably going to have to make a motion. But please push your marshal to do it, your sheriff or marshal and your process server, and see how far you go. But be ready to make a motion on it,
okay.
Because no one's gotten that far.
Can we buy index numbers for holdover cases, residential and commercial? And if so, how do we electronically do that?
Yeah, so housing courts requiring you to use NYSIF, even though they've never done that before. Unfortunately, it's not working at this time. So the answer is not yet, but you will be able to. Once again, start your case in state Supreme Court. You can buy it there.
People are asking, how do the suburbs compare in mortgage lending compared to New York City? Are they similar issues?
Well, mortgage lending is national. So credit has dried up. Commercially, it's really, really hard. You need to basically get private funding. Residentially, it's scary. I mean, this is the time where we need more credit than ever before, and it's just not there. And you basically need almost a 700 credit score, which is really high, and you need to be able to put down 20%.
Okay. Can a New York City case be brought in Westchester, which is the landlord's residence?
I wouldn't mess around with that. Westchester's not going to want it. It's going to be set back down. You're wasting a lot of your client's time. You got to bring in New York City. If the property's in New York City and it's a landlord-tenant case and you're bringing in Westchester, you're wasting a lot of months, and I think it's a bad decision.
Okay. This is going back to the holdover question. Who authorized DOI to stop notices of evictions and evictions in holdover cases? Marshals have been prevented from serving by DOI. My cases are holdover and we have warrants past EED dates.
That shouldn't be happening. It depends on what type of case, and is it commercial, residential, what are the facts behind it? But it sounds like you need to file the proper affidavit, whether they're unemployed or afflicted by COVID-19, to get those through. You may not be doing that.
Okay. And the last question I have for now is, are there any new enactments regarding guarantors in Westchester and Putnam County?
Beyond the scope of this lecture, but that's going to take too long.
Okay, got it.
Yeah. But the state, any state, ready? Let me answer it. Hold on. Anytime I talk about the state instead of the city, that applies to Westchester and Putnam. That answers the question perfectly.
Okay.
Anytime I say state, that's Westchester and Putnam. Anytime I say city, that doesn't include Westchester or Putnam. Perfect. I answered it.
If you commence a landlord-tenant case in
I can't hear you.
Oh, sorry.
Okay.
If you commence a landlord-tenant case.
Wait, I just couldn't hear you. I get interrupted by Siri.
Oh, you got me? Okay.
Wait, one more time. Hold on. Okay. I'm sorry. Go ahead.
If you commence a landlord-tenant case in Supreme, can the Supreme Court send the case to civil court like 325 cases?
Yes, we're very worried about that. And then what we're going to do, if they do that, we're going to make a motion bringing it back and bringing in all the constitutionality arguments, saying that civil court is not taking those cases and because it's a fake court, because it's really closed and it's not really open, that the Supreme Court must take it.
Okay. So what happens if you file a commercial holdover
now? When you're going through hell, keep going. Winston Churchill once said.
Is there any specific formula to indicate a person's inability to pay rent, or for a company's inability to pay rent?
Any specific formula for what?
To indicate a person's inability to pay rent, or a company's inability to pay rent. Like, how do they decide who would qualify?
So we send out, how our firm does it is we send out a pre-negotiation agreement where we ask for all their assets, a copy of their PPP checks. We want to know everything about them, a copy of their bank accounts to see what the financial status is. We require that because it only happened at the end of March, so we require March and April rents be pulled. We draw down on a security deposit. So usually that takes us, we have April and May rent paid. We draw down on security. That brings us to July. So we're usually good through July, and that's where they need to make a deal. And now they fill out all these forms about how much money they have, and now we're ready to talk about abatements and deferments.
Sure. I have one more question. It says, if you have an order of reference on a foreclosure having prevailed on a motion for summary judgment in March 2020, can you proceed with the referee's computation and then to judgment of foreclosure? This is a vacant building. Yes,
but you have to start, as long as there's two attorneys, you can start with that, but you have to start with a 2-attorney settlement conference.
Okay. And is the executive order regarding security deposits apply only to residential tenants?
Yes, that's only residential.
Thank you. And somebody was just asking is there a copy of a pre-negotiation agreement that we can send?
I'd be very impressed if any attorney gave out the pre-negotiation agreement, because it's like a secret weapon that you don't want to get into the wrong hands. I mean, that's a work of art.
Okay, so right now I have 2 more questions. Are we good for 2 more questions?
Yeah, because you're out. It looks like we're out of the 5 minutes. So yes, we're gonna have. Yeah.
What about using prepaid rent, such as for the last 2 months of the lease for current rent past due?
So this is commercial, right? Because remember, residential. Okay, residential, you're only allowed 1 month security since June 2019. So if it's an old lease, you're good. If it's a new lease, you only have 1 month security. So go ahead, Bill. I'm sorry. Go ahead. What's the question again?
What about using prepaid rent, such as for the last 2 months of the lease for current past due rent?
Well, using prepaid rent for
current past due rent. Maybe I'm
for commercial. Commercial, yes. Draw down on a security deposit. Absolutely. Take any money you have, letter of credit, prepaid rent, security deposits. Check your lease. Make sure that there's no notice provision, or if there is, give out the notice and take that money. Because if they go into bankruptcy, it's going to be antecedent to the bankruptcy estate. So you want to take that money now. Okay. Very important. Yeah.
Got it. Okay, this we're going to take the last question, and yes, they did clarify it was for commercial, their question. Will a commercial holdover filed now be put on the calendar in New York courts?
I can't answer that question because I don't want them taking my cases and making an example out of them. So that person can email me on the side.
Sounds good.
By the way, there are judges participating on this call, just so you know. I mean, on this presentation.
All right, I think those were all the questions for now.
How much time do we have left?
We're almost out of time, but if you want to go for 5 more minutes, you can go ahead and finish up.
Okay.
And everyone can stay on.
So these are the privacy laws. They're self-explanatory. Diana, you're going to share these slides with everybody?
I am. I'm going to, yes, right, because you had your presentation right up to the minute. So, and then if things are changing. So yes, right after the presentation, I'm going to send everyone your PDF.
Right. And if everybody wants, I could send them my next newsletter, but that's up to you. I mean, that's up to them. I don't know how to get a yes or no on that. Which is going to have more articles and this stuff. Okay. So I'm going to skip the privacy because it's self-explanatory. I'm going to get to the things that need discussion. Okay. Okay. This is very important. Okay. This is only as of June. The Holy Properties case versus Kenneth Cole, which one of my partners won, has been amended as of June 2019. A landlord is required to mitigate damages. This is as of June 2019. This is new law. So if, we're expecting this depression, or worse than a depression, because the depression was only 20% unemployment. We're going to beat that. So when someone hands back an apartment, you can't just sit there and keep it empty. You have to try to advertise it. You need to keep records of advertising it. This new law requires you to do that. All right, 5 more minutes. Okay. Next one. There's a lot of harassment law. There's a lot of harassment laws. I got to get rid of Siri. Okay. There's a lot of harassment laws. And thanks to Dov Tryman, who I believe is on this lecture, he put this together on this morning because I thought this was a better idea than having the other slide I was thinking of. Thank you, Dov. And this gives you a list. So when you start negotiating with your commercial and your residential tenants, you need to be aware of the trouble you can get into. So you want to be sending out emails asking for written consent or an email back that you have permission to speak with them, because you don't want to be, being a nice guy trying to negotiate with them, and all of a sudden you're getting hit with a landlord lawsuit that you're harassing them. And some of these have really, really strict, rough penalties. So harassment is a C violation. Using force or threats against the tenant. Now you think I would never use a force or threat against a tenant. Well, I said something stupid once and it wound up costing me a lot of pain. Lying to a tenant about the apartment. Yeah, well, don't do that. Lying about rent stabilization on applications for a building permit. This is harassment. Repeatedly interrupting or discontinuing essential services. Obviously, no one that's signing up for one of my lectures is ever going to do that. But you just got to make sure the services are working, because some people think anytime that there's an interruption in services, it's intentional. One interruption or discontinuance of a service in a particular apartment where the whole building has been subject to such interruptions, could be it. Repeatedly having Class C violations. Okay. Let me just get to the, bringing one frivolous lawsuit against a particular tenant where there has been other frivolous lawsuits in the building is harassment. Okay, you have the list. Just be careful when you're navigating through this chaotic mess of a city where the sky is falling and where looting buildings is considered a protest. And when you're doing your best to practice law, and it's being stopped because they closed the courts on you. And you're trying to represent clients, and you can't go to a governmental agency because they won't hear you. So I'm hoping that this presentation is helping a little bit as we navigate the most difficult time ever in our careers and ever as lawyers and as business people and as judges. And I wish you all good fortune as we navigate through. We will get through this. New York will come back. We will survive. We will persevere. But it's going to take, lawyers, the best lawyers, to be leaders and take us through it. Thank you so much for listening to me for an hour. And, may you have destiny on your side. Thank you.
Thanks everyone for coming, and thank you, Adam, for a great lecture. This afternoon, everyone will get another copy of the affirmation in case you don't have it, along with the materials. And we look forward to seeing you at the next CLE. Thanks again, Adam, and have a great afternoon, everyone.
Thank you.